Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon have the opportunity to ask questions and interact with our speaker. It feels like it has been forever since I've been live with you all, so I'm very excited, and I would love it if you got involved and send over some questions for David this afternoon. If you have a question, please put it in the comments section below the video. We will read them and make sure we address them. As always, well, I guess not always, but mostly episodes are released each week following the live broadcast. So be sure to hit the subscribe button and click the alerts icon so you don't miss an episode. So today we have David Stradley with us to talk about a few different topics. We're going to go through focus groups, some depositions, topics, and things like that, and some openings, maybe if we have some time for it, some tips on openings. David's coming from us out of the Carolinas, I believe the North Carolina, if I'm to be specific, where he practices law. He's also KTI faculty and has been a referring attorney. So with such an impressive resume, you're going to want to listen to what David has to say today. David, please share with us your insight into these topics. Let's chat for an hour about all you know and all you're willing to share with us.
Well, thank you, Jenna. Proud to be here. Honored to participate, and glad to chat with you and hopefully get some questions from the audience. So I started thinking about what I wanted to talk about today, and I said, well, I've been around this Don Keenan guy for quite a while now, and at some point I started thinking, how can I make my resume look more like Don Keenan's resume? Mm-hmm. And I said, it's a little too late to go join the Marine Corps, mm-hmm. and it's a little too late to start, trying big cases as a puppy lawyer. Mm-hmm. So what is it that I can do? What is it that sets him apart that maybe I can emulate and try to become more like Papa Don, at least in terms of my outcomes. And what I settled on, because, there's lots of successful trial lawyers, not very many as successful as Don, but there are a number of successful trial lawyers out there. And I'm, in talking with Papa Don and watching him over the years, I said, what is it that sets him apart? At least what is it that sets him apart that maybe I can do? And the answer that I kept coming back to is focus groups. Don was one of the first plaintiffs lawyers to do focus groups. And I'm sure one of the first, maybe the first to commit to them in a big way. And he's put, colleges out there to teach us how to do them. And I thought, well, that's huge. And so we do a lot of focus groups. I mean, we do a ton of them. In fact, I was meeting with a lawyer the other day, very fine lawyer here in Raleigh, and about a case. And I said, and we were going to think about working on it together, but it was something that it's a police shooting case. And that's not my wheelhouse. And she was very interested in the case. And I said, well, I think I like it, but all I've seen is we haven't been able to get the body cam video yet. We've seen it, but we can't get a copy of it. And I said, I haven't focus grouped it yet because I don't have the body cam photo. And she said, and this is a very accomplished lawyer, she said, you focus group on intake? I said, yeah, I focus group on intake. Papa Don focus groups on intake. I focus group on intake. And that's not to say, you got to focus group every car wreck case that comes in. I mean, we know generally how car wreck cases go. It's also not to say you shouldn't do focus group cases on car wreck cases, but maybe you don't, focus groups on car wreck cases, but maybe you don't have to do one, before you sign it up. So that's one of the huge things that sets Don apart, that not only I can do, you can do, we can all do focus groups. And the importance of them cannot be overstressed, because, and I think you see this, if you ever talk to Don about a case, particularly about a new case. Yeah, Papa Don, I got this case came in. What do you think about this? What do you think about that? He may give you a thought or two, but he's gonna temper it real quick with saying, I don't get a vote. And because only the focus group gets a vote. And if Don, with all his experience, doesn't get a vote, then I daggone sure don't get a vote. It's incredibly important to do these. We all, I assume everybody on this, listen to this podcast, they're either lawyers or they're masochists, or they wouldn't be listening to this podcast.
Hey, we're pretty fun. We're pretty
all right.
Inspire some folks to become lawyers because of how fun we are.
Maybe. Okay. All right. Oh, fair enough. Fair enough. We're pretty fun crowd. And so, we all, because we're all lawyers, we all suffer from law school brain damage, right? I mean, you go to law school, you never think like a non-lawyer again. You have law school brain damage, and as Don says, if you want to know something about your case, the last person you need to ask is another lawyer. Because, I mean, look, if you want to know whether your case is going to make it past summary judgment, go ask a lawyer that. But if you want to know what a jury's going to do with your case, the last person you need to ask is a lawyer. I don't care how experienced they are. Because if Don Keenan says he doesn't know what they're going to do with the case, then nobody else knows either. So, so why do we focus group cases on intake? And the real reason to that, the summary reason on that is you don't know what you don't know. You got a new case, particularly if it's a new set of facts. Like I said, if it's a car wreck case, okay. But if it's something that's not extremely familiar to you, and you don't know a whole lot about it, you need to focus group it, and that's any medical malpractice case, and for that matter, any case that you're going to have a significant investment of time or money into needs to be focus grouped on very soon after you take the case in. Even if it's a tractor trailer case that is solid, you need to focus group it and find out, is it as good as you think it is? Is there some negative attribution lurking in that case that you haven't seen? What is it that you don't know? I mean, in a medical malpractice case, you don't know what you've got. You don't know whether the codes are going to work. You just don't know what you've got until you at least started to focus group. Another thing, when you start focus grouping the case, particularly when you don't know a lot about it, you don't know a ton about the case when it comes in, you're just giving them a narrative or a timeline of the events and getting reactions to what happened. That's a real good time to start figuring out who your bad jurors are going to be. Because if you've got 6 or 8 people on a focus group, and I don't like to have many more than that. I mean, I know some people probably differ on that. I don't like to go much over 8.
Yeah, I agree, especially with Zoom. Yeah, but
particularly with Zoom, I don't like to go much over 8. But if you got 6 folks who are like strong for you, and you got 2 people over here who are not getting on the wagon, you got to, it's a pretty good place to start with, okay, well, what is it about those 2 people that, what is it about them? How did they respond in voir dire? What is it about them that they don't like this case, causes them not to like this case? And it could just be something, they could just be weird, right? I mean, it could just be, something weird about them. But more likely than not, there's something in their background that's somewhat widespread that other people in your actual jury pool might share, that you can identify. And you're not going to be able to identify it with one focus group. But if you keep track of who your negative jurors are, at some point, and you're doing several focus groups on a case, at some point you're going to figure out, hey, young mothers are terrible for me on this case. And there are cases like that. There are cases where young moms are just death.
It's always the least, you might think in a kid case, right? Gosh, the young moms are going to be right on my side, and then they're all against you, and you're like, what? Or like with sexual harassment, the women are terrible on a jury. You don't, if you have a female victim, just little things like that, but you only know those things if you do a bunch of focus groups and develop that pattern.
That's right. And until you do that, you just don't know. And worse than that, if you have tendencies like I do, which I fight against constantly, you probably think you know.
Yeah.
But you don't know, which is even more dangerous. And so, that's key. And so, every focus group you do on a case is good for identifying the people who are not going to respond favorably to your case. And why not start early? Why not start on that from the very beginning? Another thing we talk about in the edge is trying the lie. If you have a lie in your case, you try the lie. But the problem is that I've seen is a lot of times lawyers, myself included, think they have a lie, and you put it in front of a focus group. Focus group doesn't think it's a lie, or they don't think it's important. Yeah, they don't care, right? They don't care. And it's got to be a lie they care about. And so you don't know if you have a lie in your case until, Bubba tells you you've got a lie. That's when you know you've got it. And so, you gotta do them to know that. And the sooner you find out, the better off you are. I saw a listserv post earlier today, and I know we don't disclose listserv posts, but it was talking about getting somebody else to do one of the things in passing was I got somebody else to do a focus group for me on my case. And hey, that may work for you. But I'm gonna make an argument as to why we all ought to be doing our own focus groups. And it doesn't mean you have to do every one of them, but maybe somebody in your firm does a case, and you don't have to do them all. But if you're not doing your own focus groups, you're really cheating yourself out of a good opportunity to interact with jurors or prospective jurors. So my practice is catastrophic injury cases, insurance bad faith, and a small number, very small, like 1, 2 consumer class action type things. And so I do not get to try very many cases because bad faith cases, for example, if you do the discovery right, they're going to buy the case out from under you 99 times out of 100. If you did the case selection right and you did the discovery right, they're going to buy it from you. Catastrophic injury cases, you probably know as well, if you do the case right, they're probably going to try to buy it from you. It's the rare case that you get to try. I got to try one a couple of weeks ago, turned out pretty good. But we don't get in the courtroom all that often. And so maybe if you're the kind of person who's in the courtroom, multiple times a year or, something like that, you don't need the practice with the focus group like I do. But, you do these focus groups, you do the voir dire in the focus group, and then you debrief folks. You're getting some really, really, really good voir dire practice. I practice in a jurisdiction where we get to pick juries. We spent a day picking a jury for a case that was 4 days total. And so that's pretty nice. I know a lot of folks don't have that luxury. And before I started doing focus groups, well, most people will know me, will tell you that I'm, a lack of self-confidence is not one of my problems. But I will tell you that every time before I started doing a lot of focus groups, every time I stepped into a courtroom to start doing voir dire, I was quite nervous. And, 2 weeks ago, going to pick a jury, and, it was just like talking to somebody on a Friday afternoon in a focus group, and because you do it all, you just do it all the time. You don't do a full-blown voir dire in every focus group. Obviously, you don't have time for that. But it was quite natural, quite easy. If you take the voir dire class and the steps, they're quite easy to execute because you're in the habit of doing it. And there's just not. I'm unaware of any other way to get that kind of experience other than going and trying cases. And, trials are expensive. Trials take a long time. Trials take a lot of work. The focus group gives you a lot of really, really good experience interacting with jurors, talking about, issues like you're going to be talking about in voir dire, generating crosstalk between jurors, which is always the hardest thing to do.
Yeah.
Other than spotting the rats, which can be hard to do. But as a referring attorney, we watch a lot of focus groups that KTI, that the Keenan law firm does. And it is a rare focus group that you watch the voir dire and then you watch the debrief of the case. And it is a rare focus group that Papa Don doesn't do the voir dire. And, why is that? Well, he really enjoys it and it keeps him sharp. So that has, the folks that work with me have figured out that, you're probably not going to get a lot of chances to do voir dire in the focus group if David's in the office on focus group days, because he's going to want to do that. But I try to share, but it's really valuable and it's a lot of fun. And so if you're not doing your own focus groups, you really ought to do it. I'll talk just a minute about logistics for focus groups. I guess everybody knows by now. I mean, I'm 3 years late to the party, talking about this, but Zoom is the best thing to happen to focus groups like ever. We still have the room. We just need to convert it to something else. We have a room in our office that was dedicated to focus groups, set up to videotape them, mics in the ceiling, platform for the second row of jurors to sit on, whole 9 yards, and big flat screen on the wall. We, did it up right. And that hasn't been used for a focus group since February of 2020 or something like that, before the pandemic hit. And I don't have any plans to ever use it again. I kept thinking that, we'll get back to live focus groups and, eventually we'll get back to in-person and don't get me wrong. I think there's some advantage to doing it. It's just, I'm not sure the juice is worth the squeeze compared to Zoom. You get to fish for participants in so much bigger a pond than you do when you're doing them in person. You have to pay them more because they have to drive to your office and drive home. Now, a very real concern is you got strangers you got 6 or 8 strangers in your office. one or two of whom may have COVID. So it's hard to, it's hard to get back, for me, to get back doing that. Not critical of anybody who chooses to do it otherwise, but it's hard for us to get back to it. And so we can recruit from across the country. And if you think that a particular venue is important, they really aren't terribly important, we don't think. But if for some reason you think a particular venue is important, you can recruit from that venue, and instead of having to, get in your car and drive across the state and rent a hotel conference room, you can just recruit from that venue or from right around. Maybe it's a small county. We have a lot of, we have 100 counties in North Carolina. So that's a lot of counties we're a medium-sized state. That's a lot of counties. So we have some real small counties. And if you got a case pending in a real small county, you probably don't want to do pull your focus group participants from that county. Just too big a chance of them showing up on a jury veneering. But you can go to counties, you can recruit from counties around that are going to be demographically similar to your venue and do it that way. Works great on Zoom. Like I say, we pay them a little bit less than we used to pay people who were in person for the same amount of time. Zoom works fantastic. We have there's about 4 or 5 firms that have kind of gone together and formed a little collaborative. And one of the lawyers, paralegals, has agreed to do our recruiting and manage that kind of stuff for us. And we pay her by the focus group. And she handles, I say, hey, I want to do a focus group next Friday afternoon. And she says, yeah, I can cover that. Or how about Thursday? And all I do is show up and I've got my people on the screen and I'm ready to go. So, and I encourage folks to, get together with other Edge lawyers, and they don't even have to be in your state, or you're certainly not to be in your town. I mean, Jenna, you and I could, we could, if I'm doing a 4-hour focus group, you and I could split it. I mean, because it doesn't matter where folks are from. I tend to work on a small number of cases at a time, so I might not be able to fill up 4 hours of a focus group because I don't want to, I may have multiple issues in the same case I need to focus group, but I don't want to do those with the same group. So I may not need 4 hours. And so you get up with some of your buddies or put out on a listserv, hey, I'm doing a focus group next Thursday. It's 4 hours. I only need 2. Anybody need 2 hours of focus group time? Here's the cost. And anytime we do this, we don't mark it up. We just, this is what it's cost, reimburse me for my out of pocket. And so, it's so easy to do these now, that, it's really, really just super easy. Easy to record them. We're recording this. Record your focus group the same way. And then one thing we do, and maybe other people do this. I know Don always, back in the before time, would always have the fellow's job was to transcribe the focus group. Go back, rewatch the video, transcribe the focus group. Talk about the salt mines. I mean, that's
God. That's torture.
That is like torture, right? Well, now I download the video from Zoom. I upload it to this outfit called Sonix.ai, Sonix.ai. There's a bunch of different transcription, these online transcription outfits. That's the one we happen to like the best. upload the video file there in about 15 or 20 minutes. It has processed it and transcribed it. I have a paralegal log into it. It's got the video, it's got the transcript, and you can edit it. And you click anywhere in the transcript and it goes right there to the video. It flags the words it's not sure about, and they can edit it, and they put in the names of the people who are talking. And, maybe an hour and a half of paralegal work, you've got, 2 or 3 hours worth of focus group transcribed, and you've got it right there. And as Papa Don says, the spoken word, it flies away. The written word is here to stay. You've got your focus group. You can do your memo. You can paste your screenshot of your participants in the memo. There you've got your focus group memorialized. So technology is wonderful. And the Sonics outfit, I mean, I don't know how much it costs, but it's like nothing. One more little tip I'll give folks. So then I take now I have a transcript file, which I can get in any kind of different, I can get a text file, I can get a Word document, whatever. I can then take that text file and my video, and I can upload that with a program called to a website called Synchron Video, SYNCHRON video.com. And that's who I use to sync my depositions. Upload a transcript, upload the video file, it syncs. Do the same thing with a focus group transcript. That way, if I need to make a clip for a mediation or something like that, a focus group clip, I can just, I can make a focus group clip in about, 2 minutes. I mean, and it's done. And I'm not doing a bunch of video editing and all that crap. I just, bang, bang, bang. And that's cheap. That's like $12 an hour for syncing it. And I don't know how much the Sonics is, but it's not expensive either. So, very cheap to do all this stuff. And you've got great work product that you come out with. Let's see. So I think that's what I had to say about what I wanted to say about focus groups. Happy to answer any questions if any have come in. If not, I'll move on to. Oh no, I did leave one thing out about focus groups. And you learn this if you take the course, but and I hope everybody either has taken it or will take it soon. Is the emotion question. On a scale of 1 to 10, how much do you care about what happened in this case after they've heard about the case? Where 1 is, I don't care at all, and 10 is my hair's on fire. And that is that one question will give you more insight into whether you've got a good case or not, than any other question. Now, if you focus group it once and it fizzles and nobody cares, don't give up on the case. You don't want to win the first focus group, but that does tell you, hey, there's something. What do I need to change about this? How do I need to change the way I present this? And then focus group it again, and hopefully you'll get a 7, 8. On your average, will be 7, 8, something like that. And then you've got something that you can run with. So I love that question, and it is in a lot of ways the most important question if you're going to be doing focus groups.
Absolutely. I mean, I used to think you have the law and you have the facts and you have a case. That is not true. And I've been burned because of that. I thought, listen, we have the law, we have the facts. This person is liable, or this company is liable, and people don't, jurors do not operate that way. They do not. And that's my lawyer brain, right? Law plus facts equals case. And it's just not true. And of course, that's what the black hats want to do is, law plus facts equals no case and suck out all that emotion. I did want to just mention one thing for people who are either new to focus groups or aren't quite sure how they're done. Pair up with somebody else or have maybe an edge lawyer do your case. One thing you want to make sure you're doing in your focus groups is being completely neutral or not really advocating for your case, because you don't want to get in there, present the facts in a way that's favorable to you, win your focus group and be like, booyah, I've got a good case. That's not, you're not looking for 6 to 8 yes men. You're looking for hard truths, solid feedback, that sort of thing. So there's a few law firms in the area in Washington that I do focus groups for now and again all the time. And I know they do their own, but they'll also sometimes just be like, hey, I don't have time, or, I'm a little bit too close. I just recently had a case where the lawyer was too close to the case. He loved the client. He loved the fact. And we put it in front of focus group and they tore it to pieces. And it was hard. It was very, very hard. But I got the sense also that maybe others in his firm are kind of like, hey, we need somebody else to kind of put this in front of a group so that you can see what, just maybe the downsides are. So I absolutely agree. Do your own focus groups to the extent that you can. Another thing to remember is there are a million different types of focus groups. Well, maybe not a million, but there are a lot of them. And so when we say focus group your case, that is a wide open, or I guess it's wide open terrain. There are, voir dire focus groups. There are narrative focus groups. There are all kinds of, visual focus groups. You're focus grouping a lot of different things. So maybe you feel like you want to get in there and do a focus group where you're testing your voir dire questions. I had the exact same experience you did, David, in a trial I had recently where I walked into voir dire and I was like, wow, this is just like a focus group. It feels so natural and great because I do my own focus groups. So I just want to point a couple of those things out in case folks are like, I want to do my own, but I'm too afraid or not sure, or maybe I'm a little too close to my case. And a good way to do that is to share, like David mentioned, with another group, have another lawyer present your facts, or at least kind of review maybe your facts to make sure that they're neutral, that you're presenting and not skewed in your own way, and then get through it that way. One other thing I also wanted to mention is in doing an early focus group, you can ask people what else they want to know. So that will really help you with formulating some of your discovery, or if you know that that's not something you're ever going to get, it's something to consider, whether either you present the facts differently or possibly dump the case, who knows. So yes, other than that, awesome on focus groups. What else you got for us, David?
Well, I agree 100% with all that. The other thing I would just add is, sign up for, if people are new to focus group, and sign up for the KTI focus group college.
Yep, absolutely.
That's going to teach you the basics of how to do these and get you in the habit of doing them. And that's another thing that's not a bad idea. This is unfortunately in the category of do as I say, not as I do. But we were real good before the pandemic around here because we had this collaborative group of, I don't know, 4 or 5 firms. We had a focus group every Friday afternoon, every Friday.
Wow.
Keenan Law Firm does a focus group every week. I wish I could be that disciplined. But we had 4 or 5 law firms, and we did one every Friday. Now I might not have anything. They're always done at my office because I was the one that had the room. But I may not have any. I may not be presenting any cases, today. And somebody else may have all 4 hours, or somebody may have 2, and yet somebody else have 2. And we just did them every week, and it puts some pressure on you to make sure you used your focus group time. And I'm just not as good about it with the pandemic, since we kind of now are doing them, I'll wait till I have 4 hours worth of stuff and do one. I'm not as good as I used to be about that. I think it's better if you can get in the habit of, even if you have to get 4 or 5 firms together to say, okay, we're going to do one.
Yeah. Hold each other accountable. We're going to do it together.
Exactly.
Yeah.
We're going to do it, and you got to use your time or lose it or whatever. And and so that's a good way to like you say, hold each other accountable. Anyway, let's move on. I want to talk a little bit about depositions because I have I've been hit list trained as an RA. Got the hit list training when it was in its nascency, if that's the right word. And now it's a class. Now it's a course. One of the lawyers here, Nicole McNamara, teaches that course, and it is a great method. It's a great system. Like everything in the Edge, we have a system, and so it's fantastic. But I just want to hit a few high points and encourage people who haven't taken the course to go take it, but maybe emphasize some things that I see when I talk to other lawyers or when I get on listservs and things like that I think folks might be able to use a little help on. I think I've always been somewhat focused in the way I took depositions, but the hit list system really made me focus on it. And so what is this hit list system? I'm obviously not going to give you the course here today. We don't have time for that. But the notion is that you're going to walk into your deposition with a list of 10, 15, maybe fewer hits, things that you want to get established in that deposition. And that's your agenda. That's what you're going to do. And you're not going to go digging around, poking around, turning over rocks, asking a bunch of preliminary BS questions, that like we used to do in depositions. There's a lot of things wrong with doing that. Look, if you're getting paid by the hour, that's fantastic. That's billable time. That's what one wise person once referred to as risk-free billable time, which is a defense lawyer's dream, right? Nothing bad's going to happen. I get to bill some time. If you're a plaintiff's lawyer, that's the opposite, because every minute you spend in a deposition, you're racking up court reporter bills, you're racking up a videographer bill, and you're generating transcript that you're going to have to be responsible for at trial, that you're going to have to go review and sort through to find the nuggets that are in there. And so, I want like deposition concentrate. When I go back to start reviewing for trial, I want that deposition to just be chock full of just hit. And look, if I can go into a medical malpractice case and depose the defendant in an hour and a half, that's a huge victory for me. I mean, personal victory, not winning the case, but that's great, because that means I knew what I wanted. I went and got it, and I got out. And so that's how we all ought to be taking depositions. It doesn't make sense as a plaintiff lawyer who's getting paid on a contingency fee to go in and spend 3 or 4 hours taking a 1 or 1.5 hour deposition. And I'll tell you, unless for some reason, and there are some situations where you've got some huge file and you've just got to go through it to make sure you've got everything, or, figure out what happened, or, which is not going to be it's going to be a relatively rare occasion. But there are times when you got to go take a long deposition, and those aren't fun. But by and large, you can take very focused, hit-driven depositions and get in and out in under 2 hours in pretty much any deposition, and which is very which is important. It makes your life a lot more pleasant. Now, you're going to spend a lot of time getting ready for that deposition, because you're going to spend a lot of time developing those hits, and that's what you'll learn how to do in the course. But at the end of the day, you will have you'll have a deposition that is really ready to go, that gives you everything you need for your cross exam at trial and for summary judgment and everything else. And it's in a nice, neat, compact package rather than being in 4 volumes, which I have seen when defense lawyers get started talking. Try to be focused, and it just makes your life a lot easier. A couple of other things I'll just point out that you'll learn in the college, the hit list course, is the importance of role play. Role play is important in any time you're going to be going up against a witness that is not friendly to you. And role play can be important in prepping your client for deposition. I mean, they need to get, one of the pieces of that is, some soft cross exam, and then followed up by some hard cross, the hard questions they're going to get from the other side. And doing that, so they can experience what that feels like and how they're going to answer those questions. But the role play in prep for deposition or for trial cross is in some ways similar. And the best role play is what we refer to as reverse role play. So if I'm going to be cross-examining some witness, and Jenna's going to role play this with me, I don't ask the questions. I give my questions to Jenna and let Jenna ask me the questions. And that does a couple of things for me. First of all, it lets me, to some extent, feel how that witness is going to feel when they're starting to get hit with these hard questions. And it gives me some insight as to where the choke points are, where the as Papa Don calls it, when I've really got the dog collar on. And if I'm the one having to answer the questions in the role play, I'm getting that, and I know exactly where in that cross I started to feel like I had the dog collar on me. The second thing it does is it forces me, as the person playing the witness, but who at the deposition or the trial is going to be examining the witness, it forces me to think through all the ways that I can evade the questions in a way that I might not do if I'm just drafting questions and thinking, I'm thinking about that when I'm drafting my questions anyway. But when I give those questions to Jenna and she starts firing them at me, then I can really start to try to run and see if I can, get out of the dog collar. And you can't really do that unless you do the role play and unless you really do the reverse role play where you're the one, you're sitting if you're the person who's going to be doing the exam, you actually play the witness. And that makes a huge, huge difference. And then the other thing I'll say about depositions, because people kind of look askance at you like this or about this when you suggest it, if they haven't been trained in the edge. And I know defense lawyers probably look across the table at me, and when I walk into a deposition, I always have a second chair. I always bring a second chair with me to a deposition because that's part of the system. That's the way we're taught to do it. And I know there's the folks, across the table are saying, I thought Stradley was a halfway decent lawyer, but he's always got to bring help to a deposition. He can't take a damn deposition by himself. And they're welcome to think that. The purpose of bringing the second chair has your outline, has your hit list in hand. And it is the second chair's job, whether that second chair is your senior partner or your junior associate or your paralegal. You can bring your paralegal as your second chair. It doesn't necessarily have to be another lawyer. but that person is literally the boss in the deposition. The second chair is the boss in the deposition because the second chair is the one who says, did you get it or not? Did you get the testimony you were trying to get? Did you get the hit? And if you didn't get the hit, it's their job to tell you, and it's your job to listen to them. Like I said, even if it's your paralegal or your junior associate that's saying, hey, David, you didn't get that. And I got that. No, you didn't get that. Okay, I didn't get it. So what do we need to do? I need to go back and go get the hit. If it's gettable. Now, sometimes you have great plans and, the witness is just going off in a completely different direction and you never getting that hit. That's okay. That happens. If you get 70% of your hits, you're doing pretty good. So that can happen. But if you're taking the deposition, you don't get a vote on whether or not you got the hit because you don't know. You're too busy thinking about, you're listening to the answer and you're thinking about the next question. And sometimes you think you got something that you didn't. And if you have never gone back and read a transcript where you thought you just nailed the witness on something, and then you're going back to the transcript and you're like, yeah, you read through it and like, well, I thought I got that. Okay, let me go back through it again.
Where's that great answer I got? I swear.
I know I got it. It's there. I know it is.
Darn court reporter not getting it down.
Yeah. It ain't there because you didn't get it. You thought you got it. In the heat of battle, it felt like you got it, but you didn't get it. And you don't know unless you've got a second chair with you who can say, hey, you didn't, sorry, David, you may think you're the greatest thing since sliced bread, but you didn't get that. You didn't get the hit there. And so you need, so it's got to be, as Papa Don says, that the job of the second chair is not to get out the pom-poms and say, rah, 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 what a great job you did. It's their job to tell you, you didn't get it. You didn't do it. Go back and get it again. And so that's a key thing for depositions. The final thing I'll say on depositions. Sometimes we nail our hits. We get them. But we still don't know whether a jury's going to care about those things. The things we got them, who cares? I mean, are they good? Are they good for your case? Do they help your case, hurt your case? Don't move the ball. What do they do? Well, one thing you'll learn, and I'm not going to go into the logistics of this, it's part of the class. One thing you'll learn to do is to focus group your deposition. You get your video back and focus group your deposition hits, and find out how focus group reacts to your deposition hits. And you get to hear, you learn all kinds of good stuff. I mean, you learn what they think of the witness. Maybe as important as what they think of the witness, you learn what they think of you. People have told me, I happen to think these people are deluded, but people have told me that I sometimes come on too strong. And a focus group will tell you that, is your tone, are you being overly aggressive with this person? And then, heck, a trial, I got to dial it back. Or, is that person, did the witness walk all over you? And they'll tell you that in a hurry. Focus group will tell you that in a hurry. Well, that lawyer got his ass kicked by that witness. And now you can't do your own focus group. You can't focus group your own clip, right? I mean, you got to have somebody else do the focus group because they're not going to tell you that you suck. But you got to get, your buddy to focus group that clip for you. But they'll tell you in a heartbeat if if they didn't think you did your job, they will absolutely tell you in a minute that you didn't get it.
Or I've heard, oh, the lawyer was manipulating the witness and just asking the question so many times, so they just got confused. I mean, and then they feel sorry for the defendant. You're like, interesting, good to know.
Yeah, exactly.
And you're like, but I got the hit at the end of it, didn't I? And they're like, doesn't matter. Now I feel bad for the guy.
Right. Exactly. And how do you get that? I mean, how do you get it to where you're not having to chase the guy? You do the role play.
Yeah.
And if you're really trying, if when you do that reverse role play, you're really trying to run, and you know your person who's asking the questions is having to chase you, well, you make a note of that and you say, okay, I got to ask this question in a way they can't. I got to close that door before they try to go at it. And you know you can do that. I mean, you can come back and close the door. Sometimes you can come back and close the door later, but it's always sloppier. Always neater if you get it. If you know, I call it funneling. If you get them funneled in and where they don't have any place to go, but where you want them to go, kind of like a, you know, cattle chute or something.
Yeah.
Anyway, that's that on the depositions. Let me make this thing stop.
All right. We do have a question from the audience on depositions. So the audience asks, what is the best way to pick the points you'd like to hit when you're also trying to avoid preparing the defendant or opposing counsel for your questions through written discovery?
Well, so let's talk about written discovery first of all. I think interrogatories, you know, if they took Rule 34, you know, if they took all the copies of the Rules of Civil Procedure and ripped Rule 33 out of every one of them, it wouldn't hurt my feelings very much. Interrogatories are useless. Other than the one time I like to use interrogatories is if there's documents that I need to be identified under oath, I like to use an interrogatory for that. You know, identify the claims file in a bad faith case, for example. That I want identify all the medical records in a med mal case. I want somebody under oath saying this is what there is. That's a good thing. But by all that's holy, do not send an interrogatory saying, describe how the crash occurred. You know, don't do that. Because you're going to get, all you're doing is you're going to give the lawyer a chance to write that answer and rehearse it for his client. And 9 times out of 10, if you don't do that, they're not going to rehearse that answer with their client. So, you know, be careful how you use interrogatories. As far as your, you know, what you do in the deposition, you need to get what you need to get in the deposition. You need to get their feet nailed to the floor on the facts in the deposition. And you need to, you know, and you typically need to get them to admit to your rules. And, you know, your safety rules in your case, you need to get those admitted. Or they get to look stupid or dangerous. If you've got your rules formulated right, they're going to look stupid or dangerous if they don't agree with your rules. And you'll learn that in Hillis College as well. So, you know, but there's no need to fire your trial cross-examination in your deposition, particularly if it's a case you think you're going to try. You know, you can save that, keep that in your back pocket, and just get all the stuff you need to, you know, to build that trial cross-exam at the deposition. Hope that answers that question.
And then also you can, to kind of go full circle, you can get some of your points or whatnot from focus groups, right? Well, what does Bubba need from this witness in order to find for you? And, you know, that's not the end all be all, but it's information to consider in formulating what points you want to get across.
Right.
At Edge, you don't have discovery depositions. You have proof depositions or proving depositions. You're there to get the information you need. You already know what information you need to get, and you're there to get it. You're not there to kind of like figure it out.
Right. You're there to get the defense witnesses to prove your case. Yeah. That is the point of a deposition. 99% of the time it is. Sometimes there are cases where, you know, you just got to go find out what happened. but by and large, that's right. It's there to, you're taking that deposition to get defense witness to prove your case. And I don't know how much more time we have, but I'll do just a second or two on opening statement.
Yeah, we got about 5 minutes. Go for it.
Okay, 5 minutes. Okay. So I teach the opening statement class. We used to have 2 opening statement classes. We had a sort of an undergraduate opening and a graduate opening. And I've taught the graduate class. Well, the graduate class has become the only class. They've been merged, and we're teaching the one template now. That class is actually going to be taught live in Atlanta in August. I'm going to be there teaching it.
Ooh, it'll be hot.
And yeah, it's going to be hot. Atlanta in August, not the greatest timing, but it's a chance to be live. And I'm very much, while I can live without live focus groups, live teaching is the only way to go. In my opinion, I hate teaching on Zoom, and I hope we have a big turnout in Atlanta for that class. If you don't know the advanced opening template, or if you do know it and you want to take it again, come down to Atlanta to join us. And I'll say, all I'll really say about that is a couple things. One, you will learn to do a 12-minute opening. I did a 12-minute opening 2 weeks ago in my 4-day case, which led to a $40 million verdict. And so you can do not in every case, you can't do a 12-minute opening in a med mal case, but this was a motor vehicle wreck, and you can do a 12-minute opening in a car crash case, no sweat. And you will learn how to do that in this class. And I can tell you that jurors appreciate a 12-minute opening. I mean, they're like, okay, fine. This guy he stood up for 10, 12 minutes, told me what I need to know. Boom, let's go. They like that. And it's what they expect. It's what they see on TV. And they don't understand why it takes us so damn long to try a case. They don't understand why, you can start with somebody walking around at the beginning of a 60-minute TV show, well, a 42-minute TV show or whatever. They don't understand how there can be, somebody's walking around at the beginning of that TV show, and, in 42 minutes, they end up dead. The perp, found, arrested, convicted, and tried and convicted in 42 minutes. And they don't understand why we can't do that too. We'll never be able to, but a 12-minute opening is a damn good start. So, that is key. But you also learn how to focus group your opening, and focus grouping openings is crucial, because, you got to keep working on your opening statement till you get 100% conviction. If you're not getting 100, you need to be even getting the bad jurors on your opening, because it's like there's nobody on the other side. You're unopposed. If you can't win with nobody pushing back, you really got a problem. So you got to get that opening. You got to keep working on it, and keep focus grouping it until you know that it is right. And then you're going to, if you really want to do the system, then you'll test it against the defense opening, and eventually you get to an adversarial focus group. But you're not past go if you can't get 100% conviction with your opening statement, even from the bad jurors. Just that's the way. You gotta keep going, because you're not, Don says that, they do all these cases, all these RA cases. They do adversarial focus groups in every single case, and nobody's vote ever changes after the defense opening. The case is over in opening statement. It's, basically over. Never change. Votes never change. They'll change along the way, but they'll always end up where they were after the defense opening. So you got to get your opening right. If you don't have your opening right, you're way, way, way behind the 8 ball. So come to Atlanta, we'll talk about the opening statement for 2 days.
Go to Atlanta, get your opening right, people. That's what you want to do. Go to Atlanta, get your opening right.
Yep. So there we go.
Thank you, David. Thank you for being here. And thank you to all of you who joined us this week for the episode of Fridays with Keenan's Cutting Edge. If you liked today's episode, please click that thumbs up button to feed the YouTube algorithm. Don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we have another replay, I believe. I have a meeting that conflicts with the live show, but the following week, May 26th, we'll have Mindy Bish back with us to talk about admitted liability cases. Now, these in Washington, I would say 90% of our cases are admitted liability. Yes, even with a corporate defendant in a tractor trailer case, they want that admitted liability so that you can't talk about the circumstances of the wreck, what actually caused it. They try to keep that system failure out. So I am excited to hear from Mindy about the college that teaches this sort of thing and why we should attend it and how we're going to be able to address these issues as they come up in our cases. So we'll look forward to hearing from Mindy in a couple of weeks. Have a wonderful weekend to the rest of you, and I will see you next time.